Seventh case is Griswold versus Connecticut. In 1879, the state of Connecticut passed a law prohibiting any drug or medicinal article or instrument for the purpose of preventing conception. The plaintiff in 1965 was the director of Planned Parenthood in the state and challenged the law on constitutional grounds. When they were convicted of instructing and advising married couples to use birth control. The law had previously rarely been enforced, and all was but ignored. The plaintiff was convicted of a portion of this law which made it illegal to counsel married couples in the use of contraception. Yes, there is a right to privacy that exists in the aggregation of the First, Third, Fourth, Ninth, and 14th Amendments. When viewed collectively, these constitutional rights create a zone of constitutional authority that demonstrates the right to individual privacy is inherent. The state cannot violate this right because it is a right that predates the Constitution itself. Moreover, the First Amendment itself has a penumbra or an implication that privacy is protected in particular. Eighth case is U.S. Term Limits versus Thornton. Respondent Hill filed this suit in Arkansas State Court, challenging the constitutionality of 3 of Amendment 73 to the Arkansas Constitution, which prohibits the name of an otherwise eligible candidate for Congress from appearing on the general election ballot if that candidate has already served 3 terms in the House of Representatives or 2 terms in the State Senate. The trial court held that 3 violated Article 1 of the federal Constitution, and the Arkansas Supreme Court affirmed. A plurality of the latter court concluded that the states have no authority to change, add to, or diminish the age, citizenship, and residency requirements for congressional service enumerated in the Qualifications Clause, U.S. Constitution Article 1-2, Clause 2, and Article 1-3, Clause 3, and rejected the argument that Amendment 73 is constitutional because it is formulated as a ballot access restriction rather than an outright disqualification of congressional incumbents. Basically, what this did is made it illegal for states to add requirements to congressional term limits that are set up in the Constitution, like term limits and things like that. So this career politician basically wanted to keep running for his office over and over and over every term, and he was able to do that because of this. Case number 9, Raffles versus Wichelhaus. The plaintiff, Raffles, contracted with the defendant, Wichelhaus, to sell bales of cotton at a certain price with delivery to be made by a ship named Peerless. Kind of funny, as you'll see in a second. Leaving from Bombay to be delivered in Liverpool, England. Unbeknownst to either party, there was in fact 2 ships named Peerless. And one was going to depart in October, and the other one was going to depart in December. So the contract did not specify which Peerless cotton would arrive on, and both parties were unaware that there were 2 ships named Peerless delivering cotton. So when the plaintiff didn't receive his cotton until December, he basically did not accept it because he expected it in October. He was then sued for breach of contract, but because in the end neither party specified which boat named Peerless the cotton would arrive on, he had to accept the cotton late, and he could not it was not breach of contract. So in a contract, it's very important to specify more so than just the name of the vessel you're using, but also the date, because in this case it went to show that if it's not specified, you cannot sue for breach of contract. And then we've got the 10th case, Hadley versus Baxendale. The plaintiffs in this case were millers for Gloucester. A shaft in their mill broke, rendering the entire mill inoperable. The plaintiffs brought the shaft to the defendant carrier Baxendale to have it transported to Greenwich, whereupon a replacement shaft would be fabricated to the exact same measurements and specifications as the old one. It was contracted that the shaft would be delivered and Greenwich the shaft would be delivered to Greenwich the next day. However, the defendant failed to meet the delivery date contracted, and the shaft's delivery was delayed by several days. Due to the defendant's delay, a replacement shaft could not be made and delivered on time, and plaintiff's mill remained inoperable for several more days. Plaintiffs sued the defendant for profits lost for the days the mill could not operate. After a breach, the non-breaching party can recover only those lost profits arising naturally from the breach of the contract, or those damages reasonably contemplated or foreseeable by the parties at the time of contract formation. Because plaintiffs failed to inform the defendant of the special circumstances surrounding the shaft and the fact that it was the sole reason for the mill's closure, the defendant had no reason to believe that a delay in delivering the shaft would result in several days' worth of lost profits. As a result, plaintiffs, in their original trial, should not have recovered lost profits from the defendant. Communication is key. So these are 10 cases. This is kind of cases you will be studying in law school. You don't have to memorize all these cases when you're doing your exams, but it is helpful to be able to mention things like Hadley versus Baxendale and know what it is about at the very least. In case you're given a similar scenario, you can mention that case as a precedent, which gives you something to talk about or some kind of foundation to back up your argument with. So that's it for this one. Have a good one, guys.